Dennis Davis, thank you very much for your availability and welcome to Digital Markets Research Hub. I propose to structure this conversation based on four topics and looking at the nature of competition law, at your understanding of the nature of competition law, then zooming into digital markets, asking your opinion and inviting you to highlight the situation in South Africa, which is known globally for being a very specific jurisdiction in terms of competition law enforcement and vision and priorities. And also to then at the end to blend these three elements through the prism of not your academic mind, but rather judicial mind, because you share these incarnations of being academic, being also a judge. So you are not only a thinker, you're also an actor. Let us start with the first one, namely the nature of competition law.
Well, I think that's an interesting question, Olis, because let me go back. We introduced our act in 1998, and there's a bit of a background to that I need to sketch, which I think will perhaps be able to amplify my answer. When in 1998, we were instructed, a group of us, to help draft this piece of legislation. We'd had a very partial competition act under the apartheid regime, but it wasn't particularly satisfactory. It had come about because the ANC government's policy at the time, when they came into power, was the nationalization of key industries. And so when President Mandela went to Davos for the very first time after being released, he wasn't even the president then, released from prison, and was asked about the economic policy, he replied that in essence the policy was the nationalization of the key industries such as the banks, the mines, and other concentrated industries. You will perfectly understand that didn't go down well. And the attendees at Davos sort of told him that if that was going to be the policy of the South African government, they would struggle to gain access to foreign investment. And so he came back somewhat shaken by this and said, we need to think how to deal with the concentration of industry and commerce, which had been basically characterized throughout the apartheid regime by means other than nationalization. And there was an American academic, I think called Shepard, who came and sold some of the ANC heavyweights on the idea of antitrust. And so to cut a long story short, the South African Act was born from the initiative of looking for some other alternative means by which to respond to an economy which was concentrated in a few hands, and a few white hands in particular. And so if you look at the South African Act, it actually talks about that, both in its preamble and in the objectives. What this means is that it wasn't possible for us at that point to have an act which would look something identical to a Chicago form of economics, in which only the question of price increases or output diminution was going to be the basis of the act. So the act, and you see it there, sought to try to see how antitrust could develop, or competition law could develop to an inclusive economy in which the questions of significant abuses of market power by those in power, and who would therefore subvert any possibility of a broader competitive process, how could that be curbed by antitrust? How could you promote the interests of small and medium-sized business, in particular those owned by historically disadvantaged people, which were essentially Black people? And so it's a very long-winded answer to the question. It wasn't possible for us to just cleave to a traditional competition act. So for us, competition law meant more than just worrying about the manifestations of output and price. It had to deal with structural questions and the structural questions which prohibited a fair participation in the market process by 60 million people. And so for us, competition law became the basis of how could this particular piece of legislation essentially unblock the possibilities for really robust competition in all sectors of the economy to take place.
Okay, so in this context, several questions could emerge immediately. The first being, of course, that was such a heterodox approach back that time,
Yeah.
at least from the perspective, if seen through the lens of competition law, dominated by law and economics, and the more economic approach, or whatever the vocabulary could be, neoclassical economics, the holistic, globalized perception, universalized perception, objectivized, scientifically kind of neutral, or supposed to be. Nowadays, we see that the purity of competition law or competition policy or competition metrics has been challenged from different perspectives.
Yes.
And thus, the experience of South Africa is in many respects helpful for those who try to bring it to other jurisdictions, obviously bearing in mind the specificities of South Africa, etc. But do you think that the ideas which have been challenged back then are extrapolatable to other jurisdictions, or the South African regime is so specific?
No, I don't think they're totally restricted to South Africa, because we've watched with interest the way in which broader questions of whether competition law has a role to play in respect of problems of inequality or poverty or distribution of resources have become more and more debated on the agenda, and how, to a large degree, competition law has broadened its prism to deal with these issues. Part of these, of course, are because of globalization. Part of these are something I suspect you're going to ask me in the future, which is because of the digital giants and the concentration thereof. I think that what the South African experience showed was that competition law did not have to be so narrowly restricted. Now, it's true, and you make a very astute point. When we started, we were regarded as very much an outlier. And I remember very distinctly when I was going to the OECD competition conference in Paris a long time ago, and this must be close to 20 years ago, and talking about public interest, which appeared particularly in our merger provisions, and being received somewhat incredulously by many countries, saying, how on earth do you implement this? But by the end of the debate, it was apparent to me that, oddly enough, outside of the American delegation, many other countries were now struggling with similar questions, that the narrow, a neoclassical competition position, which fetishized the idea of a market and wrenched it clear of questions of how market power could be abusive, that particular focal point became more and more important as the world encountered inequality, poverty, and, if you wish, distribution of resources in an inegalitarian way. And you could almost say this, that competition law the worldwide has at least begun to return to some extent to those early roots of the Sherman Act, which were really designed precisely to sort of democratize the economy. And I don't think South Africa is the only country anymore. Certainly when I look, many other countries have public interest, many distinguished Nobel Prize winners. I mean, two who come immediately to mind are Angus Deaton and Joseph Stiglitz, who are talking precisely in the framing that we've done now, and saying competition was to broaden its horizon, particularly that way. So I think the lessons of South Africa and its faults and its weaknesses and what we got wrong, and perhaps to some extent what we got right, are in fact illuminating for other countries.
Okay, now we somehow understand, or there's new consensus emerging, that it's not a binary system where you can be either very heterodox and a contrarian or very conservatively Chicagoan, that there are several or plethora of different models could be of coexistence or of different values within competition discourse. You can imagine. And the question is how to strike the balance, how not to went too far, because this law in economics is a common denominator which is quite neutral, and hiding behind this neutrality, it's in many respects harmful, but also in many respects very helpful.
Yes, and I think that's right. So if you look at the South African Act, it wasn't that we eschewed the concept of efficiency, nor that prices for consumers should be lower and choices should be higher. Not at all. What we were concerned about was that how do you balance that against other factors, public interest factors, etc. And you've hit the nail on the head. It's an extraordinarily difficult balancing exercise. Let me give you an illustration. Some years ago, we had to deal with Walmart. Walmart sought to enter South Africa. It's a very famous South African case. Walmart sought to enter South Africa and acquire 51% of a company called Massmart, which was essentially a smaller version. And the reason was, as we understood it, was because Walmart wanted to get a bigger footprint in Africa. So the question, they had never ever been in South Africa. And the question was whether the merger should be permitted. Now, pretty obviously, the one thing Walmart claimed was that they had the lowest prices and the greatest span of choice for consumers, particularly lower income consumers. And that was true. And so the question that focused our attention was, given their global value chain, if Walmart came into South Africa, would that affect small and medium South African businesses, particularly owned by historically disadvantaged, meaning Black South Africans, because the other supermarket chains would be forced to look for global value chains rather than South African value chains, and jettison their small South African suppliers in circumstances whereby they would look to get cheaper product from elsewhere. That was the dilemma. We solved the dilemma by allowing the merger subject to certain conditions, the preeminent one being that Walmart were obliged to set up a fund to assist small South African entrepreneurs to fit within their global scheme. But one of the economists who gave evidence in this is where the crux point comes, was Joseph Stiglitz. He actually gave expert evidence on behalf of the minister responsible for this area of law. And at the end, when it's all over, I asked him that question. I said, how do I balance, as it were, the welfare enhancement of lower prices against the welfare diminution of employment of small, medium-sized businesses? And he said then, we can't do that as economists. We've got no precise tools to do that. So your point is taken. What you're trying to do as a judge almost is a doctrine of proportionality in law, trying to balance competing interests to see that you don't undermine the consumer's interest of cheaper prices, whilst at the same time trying to vindicate some of the other promises of the act, as I mentioned. It's a very tricky, unsatisfactory in the sense of precision. Hence, of course, it was always subject to the Borkian criterion that you'll get lots of false positives and false negatives if you get judges to do that. But we have no choice.
Okay, and basically, this can be interpreted or can be read as a message that this approach doesn't undermine the foundations, the intellectual foundations of competition law. It just puts it in the broader societal context by decreasing its impact on other, its hierarchy, its taxon in the general taxonomy of societal values. Competition for some jurisdictions plays or is being subordinated to more important roles, depending obviously on the context, but it's being weighted against each other. It's like within 101.3 pretty much.
I've got it. You've got it absolutely. And that's what you've got to do. In other words, the dilemma in terms of which competition law is now located forces you into these tricky adjudicative tricky adjudicative terrain in circumstances where, no, there's none of that absolute precision. But the precision which Bork and others were talking about is a precision which purports to be neutral but never is, for the obvious reasons, as many of these economists have pointed out, because it fetishizes the idea of a neutral market, and markets are never neutral.
And I think Eleanor Fox was very clear about this, saying that you rely on neutrality is a normative position. Yeah.
Absolutely.
Okay, I get this point, but I also mentioning Eleanor Fox. I think I watched a very vivid discussion at NYU with you participating. I believe, or maybe it was another one. But anyway, so my understanding was that you somehow were trying to articulate a statement or message about the kind of counter narrative, counter discourse of competition law and policy emerging simultaneously in different jurisdictions, and also within academics of more kind of mature antitrust jurisdictions, and that this counter discourse has something in addition than just saying that competition law should be perceived in the context of other values, that it somehow tries to put forward different perception, different understanding of competition policy itself, rather than just saying that it's less that it should be less fetishized and should be contextualized. Is my understanding, did I went too far? Is interpreted?
But there is one caution, and we say that all the time in South Africa. Of course, there are these other considerations which are part of the broader competition terrain, and of course, we're battling to find some framework in terms of which we can hold this all together. But competition law alone cannot change the world, and it can't change the economy on its own. It is merely one instrument amongst many. And so I'm always worried that it overreaches itself. So, for example, now one hears about the environment being a significant factor. I see that COMESA, the Southern African Competition Authority, is now including environmental considerations into their inquiry. That's very tricky. I think people are being forced there, partly because of the failure of other areas of economic tools to do anything about it, and partly because competition law, once it moved away from that strict point that you're talking about, that so-called scientific point, it obviously invited more and more values into the inquiry. So yes, I agree with you.
So you somehow miraculously, when discussing these issues with competition law, with hardcore competition lawyers, you feel in opposition with this vision, but to this vision, and if you discuss it with purely environmentally oriented people, you are equally in opposition to their normative idealism.
Yes, you are. In the South African context, I think they know that when we deal with these questions, they know that simply relying on Chicago economics or even post-Chicago economics is not sufficient. Even the lawyers know that they're going to have to engage more broadly. So weirdly enough, although we suffer from the fact of far too few experts in the field, there's no question that I think if you compared what was put to the courts 25 years ago as to now, there's a very big difference. 25 years ago, the economic experts that were harnessed by the parties would trot out vast sections of American antitrust law. No longer.
Okay, let us move to the DMA and kind of more sui generis new competition tools. My first question is, you obviously it goes in the far water in the trend set up by this more open perception of competition policy. It also, one of the features is that it liberates the enforcers from this heavy evidential burden, or at least it gives it a little bit more gives them a little bit more oxygen, discretion in terms of interpreting significant part of obligations. So it's a very proactive tool in a sense, which presupposes selectivity, I imagine, and presupposes some making some strategic choices, and thus competition policy becomes a tool, or potentially this part of competition policy becomes a tool for designing markets rather than simply policing markets against
Yeah,
anti-competitive or illegal,
yeah,
thus,
yeah.
conduct. How do you perceive this new self-creation or self-interpretation of competition policy?
Are you talking now in terms of the new legislation like the Digital Markets Act and that sort of stuff? Is that what you're talking about? Well, I mean, I almost think competition will be, well, firstly, two things. I think competition law has been forced into that, but one of the amusing features is that many, many years ago, of course, we had the Microsoft case. And the Microsoft case is not a million miles removed from much of this. I mean, after all, if you look at the European Microsoft case, it was the argument that you can you can you can be the most efficient company and you can grow because of efficiency. But what you can't do is to perpetuate your bigness through bigness. You can grow through efficiency, and because I can produce the cheapest possible computer for you, that's one thing. But when you start preventing forms of innovation from taking place or competitors from entering, and you're using your size to do that, I mean, that's what the Microsoft case said. Of course, it raises a really interesting point, which has always troubled me, which is, and I always say this to students when I teach them. When I teach the Microsoft case, I walk around the room and I look at all the Apple computers that they've all got. And you think to yourself, well, was this not just a feature that innovation was going to outflank Microsoft as opposed to the law? And where does the balance get struck between the two? But the idea of the Digital Markets Act and that kind of legislation seems to me to kind of almost wish to codify the fundamental principles that were inherent in those earlier cases, which is that, once you're a gatekeeper, well, again, if you are going to use your status as a gatekeeper to keep people out, then there's a major problem. And we all know at least this, that this has been created to a large extent because merger law worldwide was particularly lax about allowing these, these excuse me, these large digital companies from just basically acquiring anything they liked. I mean, you suddenly have WhatsApp, and the next thing WhatsApp's taken over, so that you never have competition. So the spirit of the act and the spirit of what they're doing is absolutely correct. It's holding these large corporations, huge corporations, accountable to the markets, in which circumstances which we never dreamed that there could be such large companies that could do that. And to the extent that we go back in competition history, of course, there were large firms, so that you go back to the early steel and other cases in the States, that was the problem that they faced. We've just got it on steroids. So I'm totally in favor of that. I think what is implicit in your question, which is probably right, is it going to be easy to implement? No. And we've seen one other thing. These companies are so well resourced that they make litigation very difficult.
What I also wanted to ask about the DMA is this the self-perception of enforcers, because from my reading of this legislation and its equivalent in the UK is that you get the discretion to tailor the markets rather than simply protecting the markets by forcing the designated undertakings to comply. It's not like on-off only options. You have variety of the toolbox becomes much more diverse. And if this observation is correct or not, I wanted to ask you about if there is an appetite among within this enforcement cluster in different jurisdictions to receive more competences. Do they want to not only to protect competition but also to improve it, to design some elements of competition? Or it would be ultra virus and it's very problematic and toxic matter?
I think both are operating at the same time. And that it's such a complex area which requires a lot of technical expertise on the part of the competition authorities, often far less than the companies have themselves, that they really struggle as to develop a coherent response to this and don't always do so with success. in developing countries, the problem is even greater. And that's for two reasons. One is the ability of developing countries to be able to hold these large internet type companies, these computer companies, technology companies to account is much more difficult when you've got less well financed and weaker competition institutions. And there is always the global threat that if you go after us in our country, we'll just leave. And by the way, that's also true. That's also true about pharmaceutical companies, where there's a lot of, and that's why, if you now, you'd think twice about that if you're a corporation, if you're dealing with a large a country like India or the European Union as a whole. South Africa and countries like that are much more vulnerable, which is why the attempt now to develop an African free trade agreement, which has a competition protocol in it, becomes much, if it can work, much more viable to deal with the problem that you're talking about.
Okay, let me ask you also your how you sense the role, how you interpret the role of courts and judges in this very flexible or rather flexible interpretive endeavor, where occasionally the judges confront existential choices, and depending on their 50-50 opinion, where they will which one out of two more or less plausible options they pick, they can make significant changes to specific industry or specific business model, specific market. So how does it function from the inside? I know the question is very generic, but maybe you can offer to us some reflections which would somehow inform our understanding of things from the outside.
Yeah, I think you're right. I think it all goes back to what Lon Fuller once talked about the polycentric problem of adjudication. That if you are a judge, and particularly let's say you're dealing with a merger case, just to take a simple proposition, in a country which is battling to find foreign investment, it's a really tricky question to say, am I going to allow this and allow the foreign investment in with all the consequences that attach thereto? Or am I going to say, this is against the spirit and object of our act, and therefore out you go? And you did right. Judges obviously worry a lot about that, because the consequences of a decision can be monumental. We just had in South Africa now, at the lower level, a refusal of a merger, in a massive merger dealing with Vodacom, Vodacom being the largest of our cell phone companies. And it has huge implications for example, foreign investment and for the structuring of the digital economy. And you often, as a judge, you're often trying to battle to find that sort of safe space where you create the minimum amount of harm. You're always trying to think, can I split the baby because of precisely that binary that you face. But there's something else I should tell you about adjudication, which is also true. It may not be the case when you have specialist competition tribunals. It is unquestionably the case in a country like mine and many others, where judges who are hearing these cases are not competition specialists, may never have done a course of competition law in their lives. And they're now being asked to adjudicate on the sort of complexity that you're posing to me, and they are utterly dependent on counsel. And what happens in a country like South Africa is that we've got too few counsel who really are experts in the field. So the problem is compounded by the fact that very often, if you want to gauge with counsel as to what the consequences of decision A or B are, they look at you sort of rather quizzically without knowing what to say. And so to some extent, that's why you're dependent on the economic experts. And that in turn depends upon whether the economic expert is, notwithstanding representing a particular party, is prepared to understand that they should give you evidence to the best of their professional ability rather than trying to be an advocate for the cause. And all of those make this job a much more complex job than otherwise would be the case.
And this sounds like I wouldn't dare say universal, but I understand that this is not a purely
No, it's not a South African
subjective
problem
reason.
alone. You're absolutely right. Yes, yes, I agree.
And in this context, obviously, it's hard not to ask the question about the complex kind of competition policy and competition law glosses getting more and more complex
Well, you see,
and technical.
if I could, sorry to interrupt you, if you look at competition law, it's a unique field because it's a field in which the law is informed by economic concepts. There are not many fields like this. I know that, people say, well, you get medical negligence cases, but the facts are medical. The law is effectively the law. Here, take abuse of dominance. I can't work out what the meaning of that is by looking at the Oxford English Dictionary. So I have to be able to engage with the complexity of the economics, which underpins the whole legislative process. That makes it all the more complicated.
A crystal ball case in question. If this is an objective trend, and there were several attempts to somehow to get rid of it, and one of those is the DMA. Essentially, we make the procedural burden much easier for the enforcer by offering to them so many procedural shortcuts, by somehow mitigating the asymmetry of information, resources, and expertise available between the regulators on one hand and the strongest gatekeepers on the other. Would these intentions by the Commission and the Parliament be also somehow mitigated in the course of time by judicial authorities when interpret? So the more we enforce this new rules, the less all the ambitious attempts will evaporate it somehow.
Well, that's a very interesting question. One of the ways in which you can try to balance this is you've got to be careful. And particularly in a country such as my own and many others, where our act is to be located and interpreted in terms of a constitution, which means, to put it in American terms, you've got constitutional rights to due process. There is a sense in which a piece of legislation can be rendered unconstitutional because it tilts the burden, if you wish, far too unfairly against a defendant. But what we've tried to do with some success is to create some rebuttable evidential presumptions. That's not to say you can't come along and show us that the Commission is wrong. But for example, if you take an excessive pricing case, you can have a system where if you say the company is a dominant company with a particular form of pricing policy, you can actually put on it some evidential burden to justify why that particular policy is not anti-competitive and doesn't breach excessive. At the end of the day, the judge still has to decide all the evidence. But if you fail to provide a justification, you could be in serious trouble. So you try to even it out through an evidential burden, which is not definitive, but which assists the authority.
I see this logic. My last question to you would concern your recommendations to those who start their endeavor and their career essentially at the universities. How would you, based on so much experience you have generated and so many generations of students you have taught, so many cases you've been adjudicating upon, and so much knowledge and expertise you have produced and experienced, what would be your recommendations? What to avoid, what to do, how to do?
Firstly, I think it's a fantastic field. I have found it an absolutely fantastic field for 2 or 3 reasons. One is, and I'll come back to that, because it's at the interplay between economics and law, and two, because it's also at the center of the problem of regulation. And if you think about it, we lawyers are always battling about, where does regulation end or begin, the case may be, and what's the place of law in regulating, in this case, economic intercourse. And for me, that's why it's a very exciting field. I say to my students, you don't need absolutely to have an economics degree. But if you've done some economics, a couple of courses in economics, it helps enormously to be able to understand what the lecturer is saying, and you get it much more quickly. And I think that once you've got that, and you've got some sense of as it were, two things. For South Africa, if I can just take that, we try again, and it comes back to an earlier question, to locate the subject within the dilemma of our country. A country which inherited a racist, sexist economy, and here's a piece of legislation that can help transform that and promote social justice. So I always try to encourage students, I say to them, I know many of you just want to go and work in the plush commercial law firms, but actually this is a field that speaks to far greater interests and should interest you. And if you've done some economics, just to get the basis of microeconomics in your head, you'll pick it up from there. And then thirdly, you're in this wonderful field which is evolving all the time. And the one thing that students have, or said I have not have, is they're not technologically Luddites. When I have to discuss all these cases, it's a nightmare for me because it takes me hours to understand what the hell's going on here. They all understand computers and all that. They are technologically literate, so they've got one step ahead of my generation. And it becomes an absolutely fabulous field. I mean, I'm so delighted that people like you are teaching the subject. And I think competition law is now one of those cutting edge areas where we are trying to ensure that the global economy works for many and not just the few, and it becomes vital given what we're seeing in the world today.
Dennis Davis, thank you very much indeed for this very informative conversation.
Pleasure, and thanks for inviting me.